Status and treatment of protected persons. Section I. Provisions common to the territories of the parties to the conflict and to occupied territories. Art. Point 27. Protected persons are entitled, in all circumstances, to respect for their persons, their honor, their family rights, their religious convictions and practices, and their manners and customs. They shall at all times be humanely treated, and shall be protected especially against all acts of violence or threats thereof, and against insults and public curiosity. Women shall be especially protected against any attack on their honor, in particular against rape, enforced prostitution, or any form of indecent assault. Without prejudice to the provisions relating to their state of health, age, and sex, all protected persons shall be treated with the same consideration by the party to the conflict in whose power they are, without any adverse distinction based, in particular, on race, religion, or political opinion. However, the parties to the conflict may take such measures of control and security in regard to protected persons as may be necessary as a result of the war. Art. 28. The presence of a protected person may not be used to render certain points or areas immune from military operations. Art. 29. The party to the conflict in whose hands protected persons may be is responsible for the treatment accorded to them by its agents, irrespective of any individual responsibility which may be incurred. Art. Point 30. Protected persons shall have every facility for making application to the protecting powers, the International Committee of the Red Cross, the National Red Cross, Red Crescent, Red Lion, and Sun Society of the country where they may be, as well as to any organization that might assist them. These several organizations shall be granted all facilities for that purpose by the authorities, within the bounds set by military or security considerations. Apart from the visits of the delegates of the protecting powers and of the International Committee of the Red Cross, provided for by Article 143, the detaining or occupying powers shall facilitate as much as possible visits to protected persons by the representatives of other organizations whose object is to give spiritual aid or material relief to such persons. Art. 31. No physical or moral coercion shall be exercised against protected persons, in particular to obtain information from them or from third parties. Art. 32. The high contracting parties specifically agree that each of them is prohibited from taking any measure of such a character as to cause the physical suffering or extermination of protected persons in their hands. This prohibition applies not only to murder, torture, corporal punishment, mutilation, and medical or scientific experiments not necessitated by the medical treatment of a protected person, but also to any other measures of brutality whether applied by civilian or military agents. Art. 33. No protected person may be punished for an offense he or she has not personally committed. Collective penalties and likewise all measures of intimidation or of terrorism are prohibited. Pillage is prohibited. Reprisals against protected persons and their property are prohibited. Art. 34. The taking of hostages is prohibited. Section 2. Aliens in the territory of a party to the conflict are 35. All protected persons who may desire to leave the territory at the outset of or during a conflict shall be entitled to do so, unless their departure is contrary to the national interests of the state. The applications of such persons to leave shall be decided in accordance with regularly established procedures, and the decision shall be taken as rapidly as possible. Those persons permitted to leave may provide themselves with the necessary funds for their journey and take with them a reasonable amount of their effects and articles of personal use. If any such person is refused permission to leave the territory, he shall be entitled to have such refusal reconsidered as soon as possible by an appropriate court or administrative board designated by the detaining power for that purpose. Upon request, representatives of the protecting power shall, unless reasons of security prevent it, or the persons concerned, object, be furnished with the reasons for refusal of any request for permission to leave the territory, and be given, as expeditiously as possible, the names of all persons who have been denied permission to leave. Art. 36. Departures permitted under the foregoing article shall be carried out in satisfactory conditions as regards safety, hygiene, sanitation, and food. All costs in connection therewith, from the point of exit in the territory of the detaining power, shall be borne by the country of destination, or, in the case of accommodation in a neutral country, by the power whose nationals are benefited. The practical details of such movements may, if necessary, be settled by special agreements between the powers concerned. The foregoing shall not prejudice such special agreements as may be concluded between parties to the conflict concerning the exchange and repatriation of their nationals in enemy hands. Art. 37. Protected persons who are confined pending proceedings or serving a sentence involving loss of liberty shall during their confinement be humanely treated. As soon as they are released, they may ask to leave the territory in conformity with the foregoing articles. Art. 38. With the exception of special measures authorized by the present convention, in particular by Articles 27 and 41 thereof, the situation of protected persons shall continue to be regulated, in principle, by the provisions concerning aliens in time of peace. In any case, the following rights shall be granted to them. 1. They shall be enabled to receive the individual or collective relief that may be sent to them. 2. They shall, if their state of health so requires, receive medical attention and hospital treatment to the same extent as the nationals of the state concerned. 3. They shall be allowed to practice their religion and to receive spiritual assistance from ministers of their faith. 4. If they reside in an area particularly exposed to the dangers of war, they shall be authorized to move from that area to the same extent as the nationals of the state concerned. 5. Children under 15 years, pregnant women, and mothers of children under 7 years shall benefit by any preferential treatment to the same extent as the nationals of the state concerned. Art. 39. Protected persons who, as a result of the war, have lost their gainful employment, shall be granted the opportunity to find paid employment. That opportunity shall, subject to security considerations and to the provisions of Article 40, be equal to that enjoyed by the nationals of the power in whose territory they are. Where a party to the conflict applies to a protected person methods of control which result in his being unable to support himself, and especially if such a person is prevented for reasons of security from finding paid employment on reasonable conditions, the said party shall ensure his support and that of his dependents. Protected persons may in any case receive allowances from their home country, the protecting power, or the relief societies referred to in Article 30. Art. 40. Protected persons may be compelled to work only to the same extent as nationals of the party to the conflict in whose territory they are. If protected persons are of enemy nationality, they may only be compelled to do work which is normally necessary to ensure the feeding, sheltering, clothing, transport and health of human beings and which is not directly related to the conduct of military operations. In the cases mentioned in the two preceding paragraphs, protected persons compelled to work shall have the benefit of the same working conditions and of the same safeguards as national workers, in particular as regards wages, hours of labor, clothing and equipment, previous training and compensation for occupational accidents and diseases. If the above provisions are infringed, protected persons shall be allowed to exercise their right of complaint in accordance with Article 30. Art. 41. Should the power in whose hands protected persons may be considered the measures of control mentioned in the present convention to be inadequate, it may not have recourse to any other measure of control more severe than that of assigned residence or internment in accordance with the provisions of Articles 42 and 43. In applying the provisions of Article 39, second paragraph, to the cases of persons required to leave their usual places of residence by virtue of a decision placing them in assigned residence elsewhere, the detaining power shall be guided as closely as possible by the standards of welfare set forth in Part 3, Section 4 of this Convention. Art. 42. The internment or placing in assigned residence of protected persons may be ordered only if the security of the detaining power makes it absolutely necessary. If any person, acting through the representatives of the protecting power, voluntarily demands internment, and if his situation renders this step necessary, he shall be interned by the power in whose hands he may be. Art. 43. Any protected person who has been interned or placed in assigned residence shall be entitled to have such action reconsidered as soon as possible by an appropriate court or administrative board designated by the detaining power for that purpose. If the internment or placing in assigned residence is maintained, the court or administrative board shall periodically, and at least twice yearly, give consideration to his or her case, with a view to the favorable amendment of the initial decision, if circumstances permit. Unless the protected person's concerned object, the detaining power shall, as rapidly as possible, give the protecting power the names of any protected persons who have been interned or subjected to assigned residence, or who have been released from internment or assigned residence. The decisions of the courts or boards mentioned in the first paragraph of the present article shall also, subject to the same conditions, be notified as rapidly as possible to the protecting power. Art. Point 44. In applying the measures of control mentioned in the present convention, the detaining power shall not treat as enemy aliens exclusively on the basis of their nationality de jure of an enemy state, refugees who do not, in fact, enjoy the protection of any government. Art. 45. Protected persons shall not be transferred to a power which is not a party to the convention. This provision shall in no way constitute an obstacle to the repatriation of protected persons, or to their return to their country of residence after the cessation of hostilities. Protected persons may be transferred by the detaining power only to a power which is sub-party to the present convention and after the detaining power has satisfied itself of the willingness and ability of such transferee power to apply the present convention. If protected persons are transferred under such circumstances, responsibility for the application of the present convention rests on the power accepting them while they are in its custody. Nevertheless, if that power fails to carry out the provisions of the present convention in any important respect, the power by which the protected persons were transferred shall, upon being so notified by the protecting power, take effective measures to correct the situation or shall request the return of the protected persons. such request must be complied with. In no circumstances shall a protected person be transferred to a country where he or she may have reason to fear persecution for his or her political opinions or religious beliefs. The provisions of this article do not constitute an obstacle to the extradition, in pursuance of extradition treaties concluded before the outbreak of hostilities, of protected persons accused of offenses against ordinary criminal law. Art. 46. Insofar as they have not been previously withdrawn, restrictive measures taken regarding protected persons shall be cancelled as soon as possible after the close of hostilities. Restrictive measures affecting their property shall be cancelled, in accordance with the law of the detaining power, as soon as possible after the close of hostilities. Section 3. Occupied territories. Art. 47. Protected persons who are in occupied territory shall not be deprived, in any case or in any manner whatsoever, of the benefits of the present convention by any change introduced, as the result of the occupation of a territory, into the institutions or government of the said territory, nor by any agreement concluded between the authorities of the occupied territories and the occupying power, nor by any annexation by the latter of the whole or part of the occupied territory. Art. 48. Protected persons who are not nationals of the power whose territory is occupied may avail themselves of the right to leave the territory subject to the provisions of Article 35, and decisions thereon shall be taken according to the procedure which the occupying power shall establish in accordance with the said article. Art. 49. Individual or mass forcible transfers, as well as deportations of protected persons from occupied territory to the territory of the occupying power or to that of any other country, occupied or not, are prohibited, regardless of their motive. Nevertheless, the occupying power may undertake total or partial evacuation of a given area if the security of the population or imperative military reasons so demand. Such evacuations may not involve the displacement of protected persons outside the bounds of the occupied territory, except when for material reasons it is impossible to avoid such displacement. Persons thus evacuated shall be transferred back to their homes as soon as hostilities in the area in question have ceased. The occupying power undertaking such transfers or evacuations shall ensure, to the greatest practicable extent, that proper accommodation is provided to receive the protected persons, that the removals are effected in satisfactory conditions of hygiene, health, safety, and nutrition, and that members of the same family are not separated. The protecting power shall be informed of any transfers and evacuations as soon as they have taken place. The occupying power shall not detain protected persons in an area particularly exposed to the dangers of war unless the security of the population or imperative military reasons so demand. The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies. Art. 50. The occupying power shall, with the cooperation of the national and local authorities, facilitate the proper working of all institutions devoted to the care and education of children. The occupying power shall take all necessary steps to facilitate the identification of children and the registration of their parentage. It may not, in any case, change their personal status, nor enlist them in formations or organizations subordinate to it. Should the local institutions be inadequate for the purpose, the occupying power shall make arrangements for the maintenance and education, if possible by persons of their own nationality, language, and religion, of children who are orphaned or separated from their parents as a result of the war and who cannot be adequately cared for by a near relative or friend. A special section of the bureaus set up in accordance with Article 136 shall be responsible for taking all necessary steps to identify children whose identity is in doubt. Particulars of their parents or other near relatives should always be recorded if available. The occupying power shall not hinder the application of any preferential measures in regard to food, medical care, and protection against the effects of war, which may have been adopted prior to the occupation in favor of children under 15 years, expectant mothers, and mothers of children under 7 years. Art. 51. The occupying power may not compel protected persons to serve in its armed or auxiliary forces. No pressure or propaganda which aims at securing voluntary enlistment is permitted. The occupying power may not compel protected persons to work unless they are over 18 years of age, and then only on work which is necessary either for the needs of the army of occupation or for the public utility services, or for the feeding, sheltering, clothing, transportation, or health of the population of the occupied country. Protected persons may not be compelled to undertake any work which would involve them in the obligation of taking part in military operations. The occupying power may not compel protected persons to employ forcible means to ensure the security of the installations where they are performing compulsory labor. The work shall be carried out only in the occupied territory where the persons whose services have been requisitioned are. Every such person shall, so far as possible, be kept in his usual place of employment. Workers shall be paid a fair wage and the work shall be proportionate to their physical and intellectual capacities. The legislation in force in the occupied country concerning working conditions and safeguards as regards, in particular, such matters as wages, hours of work, equipment, preliminary training, and compensation for occupational accidents and diseases, shall be applicable to the protected persons assigned to the work referred to in this article. In no case shall requisition of labor lead to a mobilization of workers in an organization of a military or semi-military character. Art. Point 52. No contract, agreement, or regulation shall impair the right of any worker, whether voluntary or not and wherever he may be, to apply to the representatives of the protecting power in order to request the said power's intervention. All measures aiming at creating unemployment or at restricting the opportunities offered to workers in an occupied territory in order to induce them to work for the occupying power are prohibited. Art. 53. Any destruction by the occupying power of real or personal property belonging individually or collectively to private persons, or to the state, or to other public authorities, or to social or cooperative organizations, is prohibited, except where such destruction is rendered absolutely necessary by military operations. Fullest extent of the means available to it, the occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate. The occupying power may not requisition foodstuffs, articles, or medical supplies available in the occupied territory, except for use by the occupation forces and administration personnel, and then only if the requirements of the civilian population have been taken into account. Subject to the provisions of other international conventions, the occupying power shall make arrangements to ensure that fair value is paid for any requisitioned goods. The protecting power shall, at any time, be at liberty to verify. Art. 55. To the fullest extent of the means available to it, The occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate. The occupying power may not requisition foodstuffs, articles, or medical supplies available in the occupied territory, except for use by the occupation forces and administration personnel, and then only if the requirements of the civilian population have been taken into account. Subject to the provisions of other international conventions, the occupying power shall make arrangements to ensure that fair value is paid for any requisitioned goods. The protecting power shall, at any time, be at liberty to verify. Art. 55. To the fullest extent of the means available to it, the occupying power has the duty of ensuring the food and medical supplies of the population. It should, in particular, bring in the necessary foodstuffs, medical stores, and other articles if the resources of the occupied territory are inadequate. The occupying power may not requisition foodstuffs, articles, or medical supplies available in the occupied territory, except for use by the occupation. 58. The occupying power shall permit ministers of religion to give spiritual assistance to the members of their religious communities. Power shall also accept consignments. The occupying power shall also accept consignments of books and articles required for religious needs and shall facilitate their distribution in occupied territory. Art. 59. If the whole or part of the population of an occupied territory is inadequately supplied, the occupying power shall agree to relief schemes on behalf of the said population and shall facilitate them by proposal. Such schemes, which may be undertaken either by impartial humanitarian organizations such as the International Committee of the Red Cross, shall consist, in particular, of the provision of consignments of foodstuffs, medical supplies, and clothing. All contracting parties shall permit the free passage of these consignments and shall guarantee their protection. A power granting free passage to consignments on their way to territory occupied by an adverse party to the conflict shall, however, have the right to search the consignments, to regulate their passage according to prescribed times and routes, and to be reasonably satisfied through the protecting power that these consignments are to be used for the relief of the needy population and are not to be used for the benefit of the occupying power. Art. 60. Relief consignments shall in no way relieve the occupying power under Articles 55, 56, or shall in no way whatsoever divert relief consignments from the purpose for which they of urgent necessity. in the interests of the population of the occupied territory and with the consent of the protecting power. Art. #61. The distribution of the relief consignments referred to in the foregoing articles shall be carried out with the cooperation and under the supervision of the protecting power. This duty may also be delegated, by agreement between the occupying power and the protecting power, to a neutral power, to the International Committee of the Red Cross, or to any other impartial humanitarian body. Such consignments shall be exempt in occupied territory from all charges, taxes, or customs duties unless these are necessary in the interests of the economy of the territory. The occupying power shall facilitate the rapid distribution of these consignments. All contracting parties shall endeavor to permit the transit and transport, free of charge, of such relief consignments on their way to occupied territories. Art. 62. Subject to imperative reasons of security, protected persons in occupied territories shall be permitted to receive the individual relief consignments sent to them. Art. 2. By the occupying power. A. Recognized National Red Cross, Red Crescent, Red Lion, and Sun societies shall in accordance with Red Cross principles, as defined by the International Red Cross conferences. Other relief societies shall be permitted to continue their humanitarian activities under similar conditions. B. The occupying power may not require any changes in the personnel or structure of these societies, which would prejudice the aforesaid activities. The same principles shall apply to the activities and personnel of special organizations of a non-military character, which already exist or which may be established for the purpose of ensuring the living conditions of the civilian population by the maintenance of the essential public utility services, by the distribution of relief, and by the organization of rescues. Art. 64. The penal laws of the occupied territory shall remain in force, with the exception that they may be repealed or suspended by the occupying power in cases where they constitute a threat to its security or an obstacle to the application of the present convention. Subject to the latter consideration and to the necessity for ensuring the effective administration of justice, the tribunals of the occupied territory shall continue to function in respect of all offenses covered by the said laws. The occupying power may, however, subject the population of the occupied territory to provisions which are essential to enable the occupying power to fulfill its obligations under the present convention, to maintain the orderly government of the territory, and to ensure the security of the occupying power, of the members and property of the occupying forces or administration, and likewise of the establishments and lines of communication used by them. Art. 65. The penal provisions enacted by the occupying power shall not come into force before they have been published and brought to the knowledge of the inhabitants in their own language. The effect of these penal provisions shall not be retroactive. Art. 66. In case of a breach of the penal provisions promulgated by it by virtue of the second paragraph of Article 64, the occupying power may hand over the accused to its properly constituted, non-political military courts, on condition that the said courts sit in the occupied country. Courts of appeal shall preferably sit in the occupied country. Art. 67. The courts shall apply only those provisions of law which were applicable prior to the offense, and which are in accordance with general principles of law, in particular the principle that the penalty shall be proportionate to the offense. They shall take into consideration the fact that the accused is not a national of the occupying power. Art. 68. Protected persons who commit an offense which is solely intended to harm the occupying power, but which does not constitute an attempt on the life or limb of members of the occupying forces or administration, nor a grave collective danger, nor seriously damage the property of the occupying forces or administration or the installations used by them, shall be liable to internment or simple imprisonment, provided the duration of such internment or imprisonment is proportionate to the offense committed. Furthermore, internment or imprisonment shall, for such offenses, be the only measure adopted for depriving protected persons of liberty. The courts provided for under Article 66 of the present convention may at their discretion convert a sentence of imprisonment to one of internment for the same period. The penal provisions promulgated by the occupying power in accordance with Articles 64 and 65 may impose the death penalty on a protected person only in cases where the person is guilty of espionage, of serious acts of sabotage against the military installations of the occupying power, which have caused the death of one or more persons, provided that such offenses were punishable by death under the law of the occupied territory in force before the occupation began. The death penalty may not be pronounced against a protected person unless the attention of the court has been particularly called to the fact that since the accused is not a national of the occupying power, he is not bound to it by any duty of allegiance. In any case, the death penalty may not be pronounced against a protected person who was under 18 years of age at the time of the offense. Art. 69. In all cases, the duration of the period during which a protected person accused of an offense is under arrest awaiting trial or punishment shall be deducted from any period of imprisonment awarded. Art. 70. Protected persons shall not be arrested, prosecuted, or convicted by the occupying power for acts committed or for opinions expressed before the occupation or during a temporary interruption thereof, with the exception of breaches of the laws and customs of war. Nationals of the occupying power who, before the outbreak of hostilities, have sought refuge in the territory of the occupied state shall not be arrested, prosecuted, convicted, or deported from the occupied territory except for offenses committed after the outbreak of hostilities, or for offenses under common law committed before the outbreak of hostilities which, according to the law of the occupied state, would have justified extradition in time of peace. Art. 71. No sentence shall be pronounced by the competent courts of the occupying power except after a regular trial. Accused persons who are prosecuted by the occupying power shall be promptly informed, in writing, in a language which they understand, of the particulars of the charges preferred against them, and shall be brought to trial as rapidly as possible. The protecting power shall be informed of all proceedings instituted by the occupying power against protected persons in respect of charges involving the death penalty or imprisonment for 2 years or more. It shall be enabled, at any time, to obtain information regarding the state of such proceedings. Furthermore, the protecting power shall be entitled, on request, to be furnished with all particulars of these and of any other proceedings instituted by the occupying power against protected persons. The notification to the protecting power, as provided for in the second paragraph above, shall be sent immediately, and shall in any case reach the protecting power 3 weeks before the date of the first hearing. Unless, at the opening of the trial, evidence is submitted that the provisions of this article are fully complied with, the trial shall not proceed. The notification shall include the following particulars. A. Description of the accused. B. Place of residence or detention. C. Specification of the charge or charges, with mention of the penal provisions under which it is brought. D. Designation of the court which will hear the case. E. Place and date of the first hearing. Art. 72. Accused persons shall have the right to present evidence necessary to their defense and may, in particular, call witnesses. They shall have the right to be assisted by a qualified advocate or counsel of their own choice, who shall be able to visit them freely and shall enjoy the necessary facilities for preparing the defense. Failing a choice by the accused, the protecting power may provide him with an advocate or counsel. When an accused person has to meet a serious charge and the protecting power is not functioning, the occupying power, subject to the consent of the accused, shall provide an advocate or counsel. Accused persons shall, unless they freely waive such assistance, be aided by an interpreter, both during preliminary investigation and during the hearing in court. They shall have the right at any time to object to the interpreter and to ask for his replacement. Art. 7. 73. A convicted person shall have the right of appeal provided for by the laws applied by the court. He shall be fully informed of his right to appeal or petition and of the time limit within which he may do so. The penal procedure provided in the present section shall apply, as far as it is applicable, to appeals. Where the laws applied by the court make no provision for appeals, the convicted person shall have the right to petition against the finding and sentence to the competent representatives of the protecting power shall have the right to attend the trial of any protected person, unless the hearing has, as an exceptional measure, to be held in camera in the interests of the security of the occupying power, which shall then notify the protecting power. A notification in respect of the date and place of trial shall be sent to the protecting power. Any judgment involving a sentence of death or imprisonment for 2 years or more shall be communicated, with the relevant grounds, as rapidly as possible to the protecting power. The notification shall contain a reference to the notification made under Article 71, and, In the case of sentences of imprisonment, a record of judgments other than those referred to above shall be kept by the court and shall be open to inspection by representatives of the protecting power. Any period allowed for appeal in the case of sentences involving the death penalty or imprisonment of 2 years or more shall not run until notification of judgment has been received by the protecting power. Art. 75. In no case shall persons condemned to death be deprived pardon or reprieve. No death sentence shall be carried out before the expiration of a period of at least 6 months from the date of receipt by the protecting power of the notification of the final judgment confirming such death sentence, or of an order denying pardon or reprieve. Pardon or reprieve. No death sentence shall be carried out before the expiration of a period of at least 6 months from the date of receipt by the protecting power of the notification of the final judgment confirming such death sentence, or of an order denying pardon or reprieve. The 6 months period of suspension of the death sentence herein prescribed may be reduced in individual cases in circumstances of grave emergency involving an organized threat to the security of the occupying power or its forces, provided always that the protecting power is notified of such reduction and is given reasonable time and opportunity to make representative to the competent occupying authorities in respect of such death sentences. Art. 76. Protected persons accused of offenses shall be detained in the occupied country, and if convicted they shall serve their sentences therein. They shall, if possible, be separated from other detainees and shall enjoy conditions of food and hygiene which will be sufficient to keep them in good health, and which will be at least equal to those obtaining in prisons in the occupied country. They shall receive the medical attention required by their state of health. They shall also have the right to receive any spiritual assistance which they may require. Women shall be confined in separate quarters and shall be under the direct supervision of women. Proper regard shall be paid to the special treatment due to minors. Protected persons who are detained shall have the right to be visited by delegates of the protecting power and of the International Committee of the Red Cross, in accordance with the provisions of Article 143. Such persons shall have the right to receive at least one relief parcel monthly. Art. 77. Protected persons who have been accused of offenses or convicted by the courts in occupied territory shall be handed over at the close of occupation, with the relevant records, to the authorities of the liberated territory. Art. 78. If the occupying power considers it necessary, for imperative reasons of security, to take safety measures concerning protected persons, it may, at the most, subject them to assigned residence or to internment. Decisions regarding shall be made according to a regular procedure to be prescribed by the occupying power in accordance with the provisions of the present convention. This procedure shall include the right of appeal for the parties concerned. Appeals shall be decided with the least possible delay. In the event of the decision being upheld, It shall be subject to periodical review, if possible every 6 months, by a competent body set up by the said power. Protected persons made subject to assigned residence and thus required to leave their homes shall enjoy the full benefit of Article 39 of the present Convention. Section